Learn webinar titled Responding to Sexual Harassment Complaints and Conducting an Investigation. We try to get everyone back to work by 1 p.m. And just a reminder for those of you who have joined us, your microphones have been muted. There's a chat window that we encourage you to use throughout the presentation for any questions that pop up. We'll do our best to answer the questions as they are asked by the audience. Please note that this session is being recorded and will be available to members after through our online member center at slcchamber.org. I want to thank Clarkson University for hosting the webinar and assisting with this initiative for members, and St. Lawrence University for being a sponsor for this educational series. I'm very happy to introduce our presenter, Jacqueline Kelleher. Jacqueline began at Stafford Owens in 2000. Ms. Kelleher advises businesses, not-for-profits, and public entities on various legal matters, focusing on labor and employment matters, contracts, litigation, and risk management. She frequently advises clients regarding labor relations and collective bargaining, executive compensation, hiring and separation, workplace investigations, and related areas. She is the district attorney for a number of local school districts, advising on a wide range of issues. She is also the county attorney for Clinton County, New York. Ms. Kelleher has a broad legal background representing a range of clients in mediation, arbitration, and before regulatory agencies in state and federal courts. She is dedicated to her community and says she was delighted to have an opportunity to become part of the social and business fabric of the North Country, partly through her service to not-for-profits. Jackie, the floor is yours.
All right, thank you for that introduction. As Mike said, my name is Jackie Kelleher. I am a lawyer in Plattsburgh at the Stafford Owens Law Firm, and I do a lot of work that involves employment law. And for the last year or so, the whole issue of sexual harassment and New York's new laws relating to sexual harassment have been a frequent topic to speak to my clients about and presentations like this. So thank you for the opportunity to be here with the St. Lawrence Chamber of Commerce. And what I'm going to do today, I've got, basically this is a presentation, very brief introduction to sexual harassment complaints, but more focused on how to conduct an investigation. The PowerPoint will be available from Mike after the seminar today, and I would encourage you to ask questions as we go through the materials, because if you have a question, someone else probably does as well. So let's get started. When you have a complaint of sexual harassment, one of the reasons that you're going to investigate the complaint is to make sure that you've got an appropriate working environment for your employees. There's also a risk management angle to this, which is reducing liability and the costs of a legal action. If you receive a complaint of sexual harassment or really any other kind of harassment or discrimination, if you ignore the complaint, if you, say, oh gosh, I know that this wasn't really sexual harassment, so I'm not going to do anything about it, you're not complying with your legal requirements to ensure that, if you are aware of harassment or discrimination going on in the workplace, that you need to take action to address it. So even if when the complaint comes in, you can tell by the nature of the complaint that it really isn't going to be sexual harassment or some other type of harassment or discrimination because it's not based on any kind of special protected status, you should still accept the complaint, do an investigation, and make a determination. The focus of this presentation is investigating sexual harassment complaints because the New York legislature has enacted a new law requiring all companies to have a sexual harassment policy that complies with certain requirements under New York law. And included in that is making sure there is a complaint form and making sure that there is part of your policy includes a procedure for conducting investigations of complaints. So if you have not updated your sexual harassment policy in the last 6 months or so, your old policy probably does not comply with the new legal requirements, and you should be looking into making sure that you do have a compliant policy in place. I'm going to talk about sexual harassment, but really this is going to apply to all kinds of discrimination, all kinds of harassment that are based on protected statuses. The protected statuses in New York, in addition to the ones related to gender, include race, disability, religion, marital status, et cetera, et cetera. So while New York is now focused very tightly on sexual harassment, really this is applicable to any kind of harassment or discrimination that might go on in the workplace. So you want to be making sure that when you get a complaint, you do an investigation that's timely, fair, and thorough. That way it demonstrates to your employees that you care about their work environment and that you're looking for the truth of what happened and not trying to prejudge the issues. And as I mentioned, New York law explicitly requires companies to have a policy on sexual harassment and a procedure for performing the investigations. In my experience, and I think most people who do this for a living would agree that most unhappy employees will pursue administrative remedies because they feel they were not treated well during the investigation or that the resolution of the complaint was not appropriate. Someone who comes to you with a problem, they really want to feel that the company is going to make a good faith effort to address that problem. The problem might not be because they are a female, because they are a transgender individual. It might just be a conflict of personalities, but even so, you want to try to address that with your employees so that they feel that, you are trying to endeavor to make sure it's a good place to work. So what triggers the need for an investigation? The employer has a duty to respond promptly when it is put on notice of a potential sexual or other type of harassment or discriminatory problem. There can be an actual knowledge, which is direct notice of a problem, generally gotten or received through a written complaint or witnessing inappropriate activity. And then there's constructive knowledge, and this is very common, where the company knows something, should have known about the conduct, or if it had investigated at all, it should have learned of it. So if the harassing conduct is widespread or well known or the subject of rumors, you can't just ignore that because the person who was the subject of the treatment or the subject of the misbehavior never came and complained to you. The right to have a harassment and discrimination-free workplace belongs to all of the people that work, and including people they don't want to have to be witnessing that conduct. So if you have constructive knowledge, if you know that some people are targeting a specific individual at work, treating that person inappropriately, you do have a duty to make further inquiry and look into it and determine whether or not something needs to be done. And one of the big changes in the new law regarding sexual harassment or prohibiting sexual harassment in New York is that they have added responsibilities for supervisors and managers. One thing that is important to be aware of is that New York State does not have a definition of who is a supervisor or who is a manager. And it is my opinion, based on many years of doing administrative hearings and that type of thing, that New York will look at fairly low-level lead employees and view them as supervisors or managers. So if you have a, head waiter, if you have a senior something or other that has some ability to supervise other people that they work with, they might be involved in scheduling and telling people when to go on breaks, they might be a crew leader, even those types of lower level promotional positions, I think, can be considered supervisors and managers. And this whole group of people now has a clear statutory responsibility to report sexual harassment when they become aware of it. And in New York State did publish a sample sexual harassment policy that a lot of companies have adopted pretty much wholeheartedly. And if you have adopted the state sample policy, there are several places where the form says that if employees are feeling like they have been subject to sexual harassment, they can complain, they can let their supervisor or manager know, and that's enough to trigger the complaint process. I strongly recommend that you revise those provisions of your policy, because many low-level, low-level promotional positions, crew chief, senior steno, whatever it may be, are not going to have the knowledge or the training to really understand when they are receiving a complaint about sexual harassment or other harassment and discrimination, and they may not report it up the food chain. So I'm recommending that people change that language to say that the report should go to an HR person, and if it can't go to that person, it would go to another title within the organization, maybe a CFO or a president of the company or someone like that, so that you're not employees are not making reports to people who really don't understand what they're receiving. And I also am, you need to make sure that these managers and supervisors are being trained to identify and report sexual harassment when they become aware of it. Think about, the crew leader who, 2 years ago was working with the people that they're now supervising, and they are used to the talk around the workstation about, oh, what did you do last weekend? And people are talking about what, they did, on dates or meeting people at bars or whatever it is, or they're making stories up, and these are just kind of Monday morning conversations. Well, now that person has a new responsibility to recognize when that can become a hostile work environment and to take steps to stop it. It's important that you provide some supports for these people and make sure that HR gives them a heads up that they have to do this type of thing, and provide support for them as they go along. So we're going to move into talking about how to, accept a report and conduct an investigation. Some of the things that you want to be aware of and concerned about during an investigation include retaliation, confidentiality, and very related to confidentiality, this idea of defamation. Retaliation is something that about 60% of all complaints to administrative agencies like the Division of Human Rights and the EEOC these days are including claims of retaliation. It has become much more common and prevalent in recent years. And those claims are taken pretty seriously because often the underlying conduct that might have given rise to the complaint about harassment or discrimination might have been unintentional, but retaliation is always viewed as a more an intentional action. And for that reason, the administrative agencies and courts are more likely to hold companies accountable for people who retaliate against others who make complaints or participate in the investigation. Confidentiality, this has been a little bit of an up and down roller coaster over the past few years. Several years ago, the NLRB, the National Labor Relations Board, decided to get very involved in reviewing employee handbooks and policies. And they said that it would violate the National Labor Relations Act to require employees to keep a investigation of workplace harassment or discrimination confidential. This is directly contrary to what their sister federal agency, the EEOC, said, where the EEOC said that these investigations should be treated very confidentially. So for several years, we had a real conflict as to whether or not you could actually have a policy that required employees to keep these types of investigations confidential. With the new Republican administration in Washington, we now have a National Labor Relations Board that has done a 180 on that, and they now say, yes, indeed, you can require confidentiality of your employees as part of this process. So it is again fine to be telling people when you are doing an investigation, you need to keep this confidential, and our policies require confidentiality, and you should not be sharing this information with anyone else. The other piece of confidentiality is very often the person who comes in and makes a complaint says, I want you to keep this confidential. Unfortunately, it's not possible to keep it 100% confidential and to perform your legal obligations to investigate the matter and to, take reasonable steps as necessary to resolve the matter. So, you can tell the person, I can't keep this 100% confidential because I now have to do something about what you're telling me about, but, I can keep it as private as possible. When an employee comes to you and says, I need to tell you something confidential, you need to be very careful to say, look, I can't promise you that I can keep anything you tell me confidential because I have obligations under the law to the company, etc. So that's always a difficult one. A lot of people do not want to, they just want to complain about something, but they don't want you to tell anyone about it or do anything about it. But the legal standard is very clear that if you receive a complaint that this harassment or discrimination is going on, you do have to take some steps. Finally, the issue of defamation. Very often the person who is the subject of a complaint feels that they are being defamed, they are being treated unfairly, that if someone says something bad about them, that that they should have a right to do something to that person. And then this is where the idea of retaliation can become problematic for the company and for the individuals involved. So again, you just need to be cognizant of the fact that the person who is accused of misconduct in the workplace is very often going to be very defensive and, calling the allegations that have been laid against that person, potentially defamatory. So sometimes you will get a complaint that is so serious or just beyond the four corners of your workspace, and that you could say, well, maybe I should be looking at some law enforcement involvement. So if you have allegations of a serious violation, and if someone is alleging that they had non-consensual sex, that their boss coerced them into having sex, I mean, that might also be looked upon as rape or some other potential, sex-related crime. So you need to sort of, you need to be cognizant of that. You may have someone coming and complaining about actions that might violate other laws in addition to your workplace prohibitions on sexual harassment. Maybe they are involving drugs or other conduct, or where threats are being made. If someone says, I feel threatened by this person is standing by my car when I go out to the parking lot, they don't want me to tell anyone what happened, I see them driving by my house. Those are all things that really, you should be definitely considering law enforcement involvement at that point, because there are, threats out there and things that can go far beyond what you are able to do in a workplace situation to take care of these things. Again, while there are lots of different kinds of complaints that might come in the workplace that you are well qualified and very experienced with investigating, there are also times that you ought to consider having an attorney at least be consulted as you're going through your process. So, if it's not clear to you that an alleged incident falls within, the four corners of your policy, you're not sure if this is something you really should be doing something about it, you definitely should consider talking to your legal counsel before you decide, I don't need to do anything about this. It's, in my opinion, it's always a better practice to at least do some limited investigation of the facts and documentation until you can conclude conclusively that it didn't fall within the policy. And if the complainant or the alleged harasser have an attorney involved, it's probably going to be helpful for you to at least have an attorney that you're calling. Sometimes an attorney will throw their weight around and you might give them the benefit of the doubt when they say, well, you have to give my client this, or my client has the right to do this. You might not know whether that's true or not. So again, you might want to be talking to your own attorney in those circumstances. Where the complainant has already filed an administrative complaint. So if this person already has something pending with the Division of Human Rights or the EEOC, or even a wage complaint with the Department of Labor, that type of thing, it's probably a good idea to get an attorney involved, probably in representing you in the pending action, but also in terms of handling the internal complaint, because it's very likely that the person will say the company is retaliating against me in some way relating to my filing of this complaint. And then again, if the complainant has or intends to make the complaint public, in HR, you might not be too concerned about that, but, the company as a whole probably would like to be prepared with some sort of response or non-response if there is something that's public, and you're going to want to make sure it is something that it's appropriate for you to say publicly about the process. Occasionally, employers will use outside legal counsel to conduct an investigation. This is often true if, a top executive is involved, because everyone within the organization works for that top executive. So they might go to an outside lawyer and have the investigation conducted by the lawyer, who's going to be seen as a little bit more objective. And sometimes you have very serious allegations, or you have allegations that are just involving so many tentacles that sometimes you want to bring in an outsider. So legal counsel does it. There's a lot of HR consultants and those types of people that also offer it as a service. You may also consider involving legal counsel to advise from behind the scenes. Make sure in a more complicated or more high stakes investigations that you are, crossing all your T's, dotting all your I's, and taking appropriate steps once you've gathered the facts and information. All right, so at this point, let's talk about planning the investigation. So, you know, companies are now required to have a written form for people to make a complaint. So hopefully the process is initiated by a written complaint. Again, a recommendation that I have, the state of New York has provided a model complaint form. I think it's not that good, quite frankly. I think you can go on the SHRM website or lots of other sites and find a better form. The one thing that I think is most important that is missing from the New York State form is they really don't ask about, you know, what would you like to see happen as a result of this investigation and complaint. In my experience, most people who file complaints, the first thing they'll say is, I don't want anybody to get fired. I just want it to stop. People understand how important a person's job is, and very often they're making a complaint about a coworker who, all things being equal, they don't hate this person. They just are not getting along with them. The person is doing things that make them uncomfortable, but they also appreciate the fact that that person who they've worked with for a number of years has kids, has a mortgage, has a mom they're taking care of, all of these types of things that we all have. And they don't want their coworker to get fired. They really just want their coworker to stop being such a dope and, you know, behave more appropriately at work. So I think that having a spot on your complaint form where you can get a sense right from the start, where does this person want this to end up? You know, they may say, I want everybody fired in that whole department, or I want to become president of the company, or whatever it may be. But very often you're going to find a fairly reasonable request, which makes it a lot easier to deal with. So, you know, the scope of the investigation is going to depend on a lot of things, such as the nature of the allegations, the source of the complaint, the specificity of the information. If it's an anonymous complaint, whether any individuals can be identified who were involved with the harassment, and the complainant's wishes. All of these are things you will consider, but none of them are going to you know, supersede what the legal requirements are for conducting an investigation. So, you know, the investigation you conduct is going to somewhat vary on, you know, based on the information that comes in at the outset and what you learn as you go along the way. So, you know, sometimes the complainant will come in and ask, I'm getting a little thing on the top. Do I need to do anything with that? No, okay. The complainant will say, you know, I you know, just want this resolved informally. I don't want a big production. I'd like, you know, I have tried telling this person not to do it. I'd like you to talk to this person and tell them to stop doing whatever it is they're doing. I want to resolve it informally. I don't want you to go talk to 50 people. So, you know, even if you have someone who is coming in and saying, I'd like it to be resolved informally, you still want to document that that was the request. You know, and then, you know, you'll have to also evaluate it if it's really a personality conflict or someone who is, you know, there's really not a whole lot of other people that might be witnessing it. You certainly can attempt to resolve it informally. If the other person involved in the complaint is cooperative, then usually that will be the end of it. But if the other person is not cooperative, is hostile, does not seem receptive to the fact that they need to adjust their behavior, you may have to take it to a more formal level. So again, while the complainant would really like to own the complaint, once they come to you, the company really owns the complaint and then is responsible for how it is going to get resolved. So, You know, one of the things that will very typically come out of any complaint about sexual harassment or other harassment and discrimination, whether it's informal or formal, is some training in the department where the problem is occurring. As I'm sure you all know, New York is now requiring that all companies provide annual training to all employees on sexual harassment. And so, you know, this is now going to become less of an unusual thing to have going on. You may also decide to send out a reminder company-wide or within the department about sexual harassment issues. You might want to, you know, be doing a climate survey, see how other people are feeling about various workplace issues and conflict. You know, you may arrange a way for the victim directly to tell the harasser to stop. I think that's pretty rare. Usually the people that are willing and interested in doing that have already taken that step. And sometimes a mediation, where you get to talk through, the people involved get to talk through some of the things that are, you know, making for some of the conflict in the workplace. So these are some of the tools that are available. You know, there's also the person, you know, the complainant comes in and talks to you, and then you talk to the other person, and then you know that, let the complainant know that everything should stop, and you know, there is no real interaction between the two of them. So let's say, you know, informal is not going to be an option. So now you have a written complaint. If the person doesn't provide a written complaint, I would strongly recommend that you sit down with them and basically ask them for all of the information that would go on the complaint form, so that you are starting with the same information you would with other people who had filled out your complaint form. You don't want to fail to find out, you know, who might have witnessed things, you know, where things happened, when they happened. You really want to make sure you understand the whole universe of what this person is complaining about and go over it before you start investigating. Because otherwise, if you begin with a nebulous complaint, you may go through a whole lot of rigmarole. You may go through a lot of you know, interviews with people, examination of documents, and then it turns out that what you are investigating is, the person says, well, that's not what I was upset about. I was upset about something else. So even if you don't get a written complaint, it's very important to make sure that you get a well-defined box of things that you are investigating, and make sure that's what the complainant wants you to look into before you start the work on the investigation. So, you know, typically a single person will do an investigation. On occasion, you might have 2 or more people involved, but then that can make credibility determinations a little more tricky. But when you are looking at, you know, who should conduct the investigation, you want to take into account the gender of the complainant and witnesses. I mean, sometimes men don't like to do an investigation that's going to involve largely a group of women. And vice versa. And then the relationship in the organization of the investigator to the complainant and the alleged harasser. Again, if the complainant works directly for you and the alleged harasser is in a different department, you might seem like a person who's not going to have an objective view of the 2 people, and you might be looking for someone else within the organization or outside the organization to do the investigation. I actually know clients who, you know, on occasion they will do an investigation for another company. You know, there's a company in their office park or whatever, and the person says, you know, I'm involved with all these people. Can you do my investigation and I will owe you one? And that can be a nice way to get someone that appears from the outside to be objective and not incur a whole lot of cost at the same time. And then the nature and the complexity of the allegations. You know, there are some complaints that are fine for your young HR generalist who just started with the company, and you know, you want to allow them to you know, grow and have some new opportunities. And then there are some that are extremely complex and should, you know, really be undertaken by someone who's got a lot of experience under their belt. Other things to consider. You know, the investigator should be knowledgeable about sexual harassment law and the company's policy and procedures for investigation. So if you're bringing in someone from the outside, whether it's to do your training on your sexual harassment policy or to conduct an investigation, they really should have your policy and make sure they are applying it correctly. You want to think about the investigator's people skills, ability to listen and to obtain the necessary information, and then any actual or apparent conflicts of interest. Again, you don't want to be investigating someone who works directly for you, or someone that, you know, you've had to take disciplinary action against recently. Those are things that might be viewed as an apparent conflict of interest. All right, so I'm going to talk about some best practices for conducting the investigation and gathering the information. This is not always going to fit. All of these things might not be available. All of these things might not be relevant in every circumstance, but if you want to use these slides as something of a checklist to say, okay, I've thought about this, I think it's not going to apply here, or there might be nothing that's responsive, but at least you will have run through a thorough list. So you want to consider looking at personnel files or other supervisory files. You know, sometimes you might have very strict rules about what goes into a personnel file, but, you know, supervisors might have notes or other things. Information concerning other prior complaints or related complaints, issues between these coworkers or other coworkers who have been mentioned as possible witnesses. You want to look at the relevant company policies. If this is some sort of discrimination or harassment that's not sexual, but perhaps related to disability, you're going to want to make sure you know company's policies on those issues. And then existing documentation, you know, you want a written complaint or you want all the information that would go into a written complaint. And then any other evidentiary materials like emails, texts, phone logs, photos. Be wary of the person that wants to give you like 5 years of notes and phone logs and all of that stuff. Often there's not going to be a whole lot of relevant information in there. You know, if someone is complaining about the texts and emails they are receiving from a coworker, by all means, look at some of them and be cautious to make sure that maybe one side of them is not being deleted, or certain things being sent by the complainant haven't been deleted. You know, so if they're company emails, you may want to go in and look and verify for yourself using your server that you're getting the full representation. There might be other issues you need to deal with. If you have unions in your workplace, there may be a requirement to contact the union to let them know this is going on. If any employee who might be subject to discipline as a result of any interview you do with them, they would have a right to have a union representative present. Doesn't mean the union representative gets to participate in the conversation. It just means they get to have them there and ask for a break or timeout if they want to talk to their union representative. And then finally, you're going to need to think about, is it necessary to transfer or suspend the subject of the investigation pending the outcome? If it's suspension is what you decide, should it be paid or unpaid? Outside of the union context, there's no requirement that a private company provide unpaid or paid leave to a person, but you might decide to do that in the interest of fairness or for lots of other reasons if you're suspending a person. So then we move into, okay, you sort of figured out the scope of what you're going to look at, and now you're planning for your interview. So you want to make sure you're doing it in a non-threatening environment. You want to take detailed notes. I like to start with open-ended questions and become more specific as the answers allow. And, you know, you want to make sure when you're talking to people what they know firsthand and what they've heard from other people. And really what you want to concentrate is on what they know firsthand, what they saw, what they heard. You want to be non-judgmental and non-confrontational. Explain while you're there. Identify how the person being interviewed is involved in the matter. You're the complainant. You were named as a potential witness. You're the subject of this complaint. You want to assure the person being interviewed that confidentiality will be maintained to the greatest extent possible. I think we've talked about this before. You can promise the matter will be treated as privately as possible, and you can require your employees to treat the contents of the interview as confidential and discipline them if they don't do that. You want to make sure that's what your policies provide. So, you know, this is something that you know, the general considerations. You always want to ask the person not to disclose the nature of the interview to other employees so that they can't start, you know, talking about the situations and maybe taint each other's memories. You know, after, you know, before you, you know, you want to tell the people why you're there. You want to talk to them about confidentiality. And then before you start really interviewing, ask them if they have any questions. Sometimes, you know, they'll, you know, have some confusion about the process, and it's good to get that cleared up. Again, at the end of the interview, when you wrap it up, talk again about confidentiality and, you know, your company's policy against retaliation. Let the person know that if they have any further information, they can contact you for follow-up, because sometimes people are a little surprised when they find themselves in one of these interviews and may think of some things later that are also relevant. And then you also want to let the complainant and the alleged harasser know that they will be advised of the outcome of the investigation. Your policy that you now have may say that they're going to be notified in writing. There may be time limits suggested. So you really want to look closely and make sure you're following your own policy. If you've adopted the policy that says, you know, the investigation will be completed in 5 days and you think that's impossible, you should change your policy. You shouldn't just ignore that requirement. Excuse me. You want to assure the complainant and witnesses that the organization will not retaliate against them due to their participation in the investigation, and ask them to report any occurrence they may believe may be retaliation. And you also want to inform the alleged harasser the organization will not tolerate any retaliation against the complainant or the witnesses. And so, you know, just make sure that that conversation is had with every single person, and ask them to follow up with you if they feel or they have questions about, am I being retaliated against? Is this okay or not? So these are now some suggested questions, you know, the information that you want to gather. So with the complainant, you want to find out about the incident or incidents, who was involved, what happened, what was said, where did it occur, when, how often, is it ongoing? And you're going to want to know about their reaction to the conduct. You know, it's not enough that something happened. You really want to make sure that they're explaining to you, how has it impacted their ability to do their job? You know, did you say something to the person? Did you say something to another person after it happened? How has the conduct affected you or your ability to do your work outside of work? You know, tell me about, you know, how this has impacted your life. You want to get some sense of the person's credibility and motivation. You know, what's your relationship with the alleged harasser? Have you had any prior problems with this person? I want to get to know a little bit about their relationship. And then you want to talk to the complainant about other evidence and potential witnesses. Like, did you talk about this incident with anyone? If so, who? I find that this is a really important bit of information. I have had a number of people tell me, yeah, I told so-and-so about it right away, and so-and-so never heard anything about it. And so, you know, that can sometimes be a good indicator on credibility determinations that you need to make. Did you see anyone immediately after the incident? Who was it? What happened? Where did you go? Did anyone witness the incident? Has anyone else complained about inappropriate conduct by this person? I mean, you may know that as the HR professional, but you may be asking, like, is anybody else in your department having a problem with this person? Because as the investigator, you want to run down all of those leads. Did you record any of this information in a diary or journal? Are there any information or documents that might be important to look at? So then once you've interviewed the complainant, you can then prepare for the rest of the investigation. You now know what the specific complaints are. You've got a list of potential witnesses, and you can, look at that and say, what order should I interview them? And then outline potential questions for each witness. And, as you're approaching these third-party interviews, these people are not necessarily going to know why they're there. They're being invited in for to discuss a workplace incident. So I always like to start with open-ended questions. Some people never have any idea why I'm there asking them questions. But you don't want to just leap right into, did you see mommy kissing Santa Claus on Christmas Eve under the mistletoe? Because that's sort of laying out the whole thing. If they say yes and then or no, and then you're done. But really, you don't want to plant this idea that this may have happened. So you want to say, do you know Mary? Do you know Joe? Have you witnessed them working together? How would you say they get along? Those types of broad questions, do they seem to have any problems with each other? And, if you don't get anything as you sort of walk through and try to find out about the relationship of those people, you may say, okay, well, that's it. This person doesn't seem to have any specific knowledge. And you don't necessarily have to go to the question of, did you see this happen? I don't like to ask that question if it's pretty clear to me that the person has not seen anything weird going on between the complainant and the subject of the complaint. So I tend to leave those questions off the table unless they do seem to have some insight into the situation. So, you're going to ask the witnesses and third parties, what did you see or hear? When did it occur? Tell me what the behavior is of this person towards the complainant, others in the workplace. Has the complainant told you anything? What and when? What's your relationship with the complainant? What's your relationship with the harasser? Can you describe the relationship with the alleged harasser? And then again, you're going to want to conclude these interviews in part by finding out, have you told anybody about this? What other information might I want to look at? Are there other people who might have information? All of this is going to help you decide, have I closed the loop on this? To everybody with knowledge, have they talked to me? Or is there a whole group of people the complainant didn't want to tell me about that might have some different information? This is going to help you decide how big the circle might be. And then finally, the alleged harasser, you want to ask them about the incidents. What is the response to each specific allegation? What did you do? What did you say? Where did it occur? When did it occur? How did the complainant respond? I will say I have had some investigations where the complainant or the alleged harasser has denied the misconduct. And so sometimes after once or twice, and they're categorically denying everything. I may not ask them about every single thing, especially if it's like at that point I've reached a conclusion. I'm probably not recommending that this person has to be terminated. I'm probably not recommending that. I'm probably not even going to. I'm not finding the complainant all that credible in her version of events. I might not put every allegation on the table because I know these people are going to have to work together going forward, and some of the things that can be said can be pretty poisonous. So I have actually had situations where I knew no one was going to lose their job, the department was not being restructured, where I left out some of the more offensive conduct that was alleged that I had by that point determined was not credible. Again, you're going to want to talk about credibility and motivation. Questions like, how would you describe your relationship with the complainant? And if they deny the allegation, why do you think the complainant might be lying about this? Are there other people who might have relevant information, other information or documents that might be important to look at? So then finally, you're going to be reaching a determination and wrapping it up. You know, you need to say, okay, did the conduct occur? And then if the answer is yes, did it actually constitute harassment based on a protected characteristic? So very often what I find is the conduct occurred, or some version of the conduct occurred, but it really wasn't based on any protected characteristic. It's really more two people not getting along in the workplace. So, but, you know, then it's not going to violate the sexual harassment policy, but there might be things you want to do about it. So in making your determination, you want to consider the evidence that includes the company's policy, your documentation that you received, the information you got from witnesses, and then any other miscellaneous information you may have gotten. So sometimes it's hard to make a credibility determination. A lot of times you might get a, well, it's a he said, she said, and I can't determine. But sometimes you can make a credibility determination. And, you know, you look at the consistency of the evidence and corroborating evidence, hearsay versus actual knowledge, motivation to tell the truth, the demeanor of those being interviewed. And, you know, those are all things that will help you figure out, is there someone who probably, I can conclude, is not telling the truth or is clearly telling the truth. Then you want to draft a written report. You're going to want to summarize the allegations. You're going to want to summarize the interviews. Again, I'm an outside person that goes in and does investigations. I will usually summarize the interview with the complainant and the alleged harasser. But the other ones, I will just say, like, 3 people mentioned this, 2 people mentioned this, 1 person said this, you know, but I don't like to attribute those things to specific people, especially if you know, there's a general feeling of unease about what's going on in the department. You know, instead I just say a lot of people seem to think these things, a lot of people seem to think these things without naming names. Then you want a summary of the findings and a discussion of the conclusions you drew from the allegations. And then if it's appropriate in your role, a discussion about recommendations and corrective action. I like to not have the investigator be the person who says the discipline of X, Y, or Z should be imposed. I think it's better for an investigator, when possible, to just say discipline ought to be considered and let someone else actually make the determination of what's appropriate. So then if the conduct occurred, but it wasn't based on a protected characteristic, you may want to do a management letter. That's what I often do, because I'll have, okay, these are the things that are relating to this allegation. It wasn't sexual harassment, so the report is unfounded. But you got a whole lot of other things going on in this department that are a problem and really need to be worked on. You might have people that don't respect each other. You might have a supervisor who's not taking steps to address those things. And that gets put in a different document, which, you know, is separate from the complaint file, but it also lets the higher ups in the organization know that while this wasn't a problem in terms of a hot policy violation, it's something that really is going to keep recurring unless they get some changes within the department. And then finally, reaching a determination and wrapping up, you need to communicate the final conclusions with the complainant and the accused in general terms. Address discipline if it's necessary and appropriate. You need to follow up with the complainant and witnesses afterwards to make sure there's no retaliation, and look at other activities to restore a comfortable working environment. Finally, it's my recommendation that you not have harassment complaints and investigations in a employee's personnel file. You should have a separate place where you keep those things, because that way, if you are ever, you know, you need to know what other investigations have we done. They're all together. You're not trying to remember who the people involved were. And again, you know, the complaint really doesn't belong in either the complainant or the subject of the complaint's personnel file. Really, the best thing would be to, if there's an outcome from this, if there's something disciplinary or otherwise, that would go in the personnel file, but the investigative stuff has its own special spot in a drawer. Thank you for inviting me here today. I hope this was helpful and informative to you, and I appreciate the opportunity to speak with you.
Thank you so much, Jackie, for sharing that wealth of knowledge. I'll open the floor up for any questions for a minute here. While we wait for questions, if there are any, I would just like to mention that next month on May 1st, we'll have Ryan Smith from the Division of Minority and Women's Business Development, who will present how to get MWBE certified with New York State. You can register for this webinar at slcchamber.org or on our Facebook page, facebook.com/slcchamber.NY. It looks like we haven't received any questions yet, Jackie, so I really appreciate you for sharing that thorough information. I'd like to tell the audience, if you have any topic ideas for future webinars, or if you're interested in participating yourself or presenting, you can contact me at mike@slcchamber.org or call 315-386-4000. So thank you everyone for joining us. And I'd like to also thank Clarkson and St. Lawrence University for sponsoring the series and supporting the Chamber. Again, all of our webinars are recorded and uploaded to slcchamber.org in our archived webinars section. Thank you and have a great afternoon.
Okay, thank you. Goodbye.
Thanks.